case number EC-15, David Lewis versus the Minister of Justice and another.
Yes, Mr. Lewis.
Should I proceed with my...
Yes.
Right.
This is just the point in time,
Right.
The appointment of the
Right.
attorneys of record.
That's correct.
Yes.
And I filed an affidavit.
Yes.
I believe that I'm really just going to expand on one of the points.
Yes.
Mr. Mohammed, as previously stated, is the head, the president of a statutory body governed by the Attorneys Act of 1979.
Yes.
As you may know, the Act creates provincial law societies tasked with administering the profession of law.
Yes.
According to Article 58 of the Act, there are a number of objectives of these societies. It's probably unnecessary for me to read all of them. I'm just going to focus on A, to maintain and enhance the prestige, status and dignity of the profession.
Yes, but Mr. Lewis,
So,
the second respondent surely has a constitutional right to appoint whoever they feel as the attorneys of record. And how can I tell them they can't appoint certain attorneys as attorneys of record?
so the president is a member of a control board.
Yes, that may be.
Right. The board itself grants, the Act itself grants extraordinary powers of inspection and discipline upon its members. And pertinent to the preliminary hearing on the appointment of the president are the facts related to a disciplinary hearing of its member, H. Cheadle, at which the president, as head of council, was presumably also a party. Since I am not a member, I was not represented at the proceedings, but was merely a complainant with no direct access to council. As it stands, the manner in which members are disciplined, as contemplated by the Act, is that it occur before a full council meeting. Correspondence in my possession from Cape Law Society refers to a disciplinary committee meeting which issued forth from their disciplinary department following a referral on the 30th of June 2011 by Lynette Bios, Secretariat for the Judicial Service Commission. Notwithstanding the appearance of a delegation of authority by way of departmentalization, the President should be aware of the outcome of the disciplinary and cannot claim ignorance. Despite a lengthy report tendered by its member and in my possession, in which the member acknowledges that a unit of the second respondent is or was a client of the member's law firm while the member was acting Justice of the Labour Court in 2010, and also in which he acknowledges holding a directorship in a labour brokerage and human resources firm, the Resolve Group, which was at the time in business with the second respondent, and which was thus also partly owned by one of the second respondent's business partners, Kagiso, which is a Remgro entity. The President is now here representing Naspers, while I'm the opposing party. I'm thus also in a possession of a letter stating that effectively the Council has declined to do anything about the problem since, quote, a finding of unprofessional conduct could not be made on the information documentation before it. This hearing is not to examine whether or not the admissions made by Cheadle constitutes conduct unbecoming, and is not lodged to unnecessary pry into the affairs of Cape Law Society without good reason. This is not the purpose of my application. However, I am exercising my right here to oppose the appointment of the President on the basis that it is inappropriate for all of the reasons supplied in my affidavit of opposition, and furthermore that it unnecessarily lowers the prestige, status and dignity of the profession by creating the impression that the President and his Council are stakeholders in the matter. The manner in which this has come to pass via the Council, the Directorate, or even the National Executive Controlling Body represents nothing more than a perversion of justice and an abrogation of responsibility by the President. Any reasonable person would comprehend that a conflict of interest exists and that the Cape Law Society is thus a party to the dispute. While the facts of the Labour Courts, the South African Human Rights Commission and the Cape Law Society process and the further national prosecution process following the decision in Lewis versus Media 24 of 2010 may not be admissible facts per se, and thus not considered evidence before this court necessarily. The de facto scrapping and or nullification of the TRC report by the second respondent and its functionaries, representatives and employees, and the facts hereto related and attached, resulting from the first respondent's negligence and the second respondent's complicity in apartheid crimes is a cause of action, and one has only to point out the extracurricular evidence presented in relation to Ton Foslu and the TRC and the post-dated mea culpa. Right.
That is not before at the moment. At
Right.
the moment, the only application I have is your objection.
Yes.
And that's what I have to deal with now. Because they are liable for the statement once he's on record.
Right. So my motion by way of affidavit, I'm opposed for the following reasons. That this application does not arise from an internal process within Cape Law Society in regard to a pro bono application made to this body by the complainant. This application does not arise from a disciplinary hearing which occurred at Cape Law, and the auxiliary factors may be related herein, in which I've attempted to expurgate on. And I can provide...
Objecting to them coming in as attorneys of record for the second respondent.
Yes, because they seem to be party to the dispute. There's a problem of conflict of interest and the public interest in this case, bearing in mind that the second respondent is a media enterprise and the first respondent is the Justice Minister. So that the public interest in this case, I think any reasonable person would come to the conclusion that Mr. Mohammed is abusing a statutory body such as the Law Society. And however that society is governed, and I understand that it seems to be a public-private enterprise itself. He's the president of that society. He should not be involved in the affairs of the members to such a degree. Whether the second respondent wants to procure an attorney isn't the case here. The case is whether or not the second respondent has a right to procure essentially a purchase of office. And this is what the accusation is made in my affidavit. It's yet another purchase of office, bearing in mind that there is a disciplinary finding made by that committee, which has now been referred to National Prosecution Service, in which I am alleging corruption, forging of documents. There's a perjury case. It's very extraordinary case where the outcome of the Labour Court decision has been perverted by a business person, a director of a Labour resources firm, who failed to disclose that he was a director at the time of an entity in business. There are several accounts held by the directors of that company, and I can demonstrate that if needs be. It's in my affidavit before National Prosecution Service, before Silas Ramati. And do I need to go on? It's inappropriate for the president of the Cape Law Society, with a man with such high office, to be representing a second respondent in which the second respondent has made egregious attacks against my presumed race identity and continues to issue forth. It is inappropriate for an attorney of such high office and or his law firm to defend an application in which one of the accusations previously made by the second respondent on record is a specious claim that he is abusing I'm abusing the faith of others by defending an art exhibition in the Boer Kaap, a history of slavery exhibition at Izika, and supplying written work related to jazz history, and still continues to do this. It's inappropriate for an attorney of such high office and or his law firm to defend an application in which the second respondent has sought to deprive me of ordinary rights and privileges accorded the profession of journalism, and has also attempted a gagging order. It is inappropriate for an attorney of such high office and his law firm to defend an application where the complainant is accused, and more recently by representatives of the second respondent, Kahanovitz Senior SC, before the Cape Bar Council, of abusing the folk music of others by deploying Boere Orkes Langarm music in a documentary which I am busy making on this whole affair. It would be inappropriate for an attorney with such high office as the president of the Cape Law Society to appear in a matter in which the second respondent has sought to deprive me of access to my religion and culture, and they are the authors of an inquisition of my Jewish identity, all on record. I condemn the second respondent and its representatives before this court for seeking to abrogate rights commonly held under our secular constitution by attempting to de jure anathematize and excommunicate me because of my adherence to an affinity with secular humanistic and or progressive Judaism. I'm not the one here with the doctrinal problem related to the apartheid heresy. I place on record my objections to the appointment of the president of the Cape Law Society or any attorneys carrying his name to what appears to be little more than another purchase of office, in order to persist in the spurious allegations made by the second respondent while affecting the appearance of a legitimate and noteworthy attorneyship. This is whilst I myself do not possess an attorney of record. Mr. Mohammed is the man who has essentially been involved. I mean, the events of the past week are clearly demonstrable, in which he's unable to assist me in procuring a member of the profession to represent me in a matter, the primary matter of which affects the outcome and status and prestige of the Truth and Reconciliation final report. The second respondent has conducted an extended campaign of purchase and presumably intends to capture the state by hook or by crook if necessary. Given the special circumstances surrounding the recent mea culpa issued by the second respondent and outlined in my submissions, it is not necessary for the second respondent to even retain attorneys. I'm also going to go into this point here that Mr. Mohammed has previously declaimed on this matter as a provincial head of the South African Human Rights Commission in Cape Town in regard to an application made to that body on the 20th of June 2006 impacting on the outcome of events before the courts. He has already issued a waiver of interest by the South African Human Rights Commission in his former capacity as provincial head. And he was apparently not at the time in a position to assist me, since the matter was particular to the labour issues and thus the subsequent record of decision, which was before the labour courts. So such a person should not now be in a position to be representing one of the parties. He's negligently and without good reason refused to offer assistance in the primary matter, impacting on and following from the outcome of the TRC on the basis that it's merely a labour dispute. The internal complaint process, so far as that body, the Human Rights Commission, is concerned, has already gone to ground in a parallel process. And so far as the appeals process is concerned, before that body, I don't intend to avail myself of the finding which was made by that body, where they courteously gave me a 180-day period in which to examine their decisions before the courts. I don't intend to renew that process. I'm not resurrecting the parallel processes in which Mr. Mohammed has been doubling up once again in his attempt to get ahead of the de jure equality court process already underway. I therefore seek relief. I seek immediate order for costs, and that the case is dismissed, and that there is some kind of relief for. Right.
Order that the firm not act as attorneys of record for the second respondent.
I believe so.
Isn't that?
I believe you're correct. Yes.
That's your application.
Yes.
The main application will be heard at some other stage.
Right.
That's all I'm dealing with now.
I rest my case then, Your Honour.
That is correct.
Do you have anything to add?
We have no submissions.
No submissions. Right.
The court pleases.
Yes. Awesome.
The applicant seeks to have Mr. Mohammed barred from acting as the second respondent's attorney in these proceedings. My Lord, to deprive a party to legal proceedings of its legal representation is a grave interference with its right to freely choose its legal representative. It is also an interference with its legal representative's right to practice his profession. And so, my Lord, relief of this kind will be granted only in exceptional cases and on very specific grounds. And the recognized interest in South African law is that of side switching, where an attorney acts against somebody who was previously his client. And even in this instance, my Lord, the attorney won't be barred unless specific requirements are met. And in that regard, may I just hand up to your Lordship the case of Wishart and others versus Bleeden and others. Now, refer your Lordship to paragraph 50. In this case, Gorvin J. looked carefully at the principles of law in our law governing this situation, and in paragraph 50 set out the requirements for a barring of an attorney on the basis of a previous attorney-client relationship. First of all, it must be shown that the attorney concerned had a previous attorney-client relationship with the party, that confidential information of the applicant was imparted or received in confidence as a result of that relationship, that the information remains confidential, the information is relevant to the matter at hand, and the interests of the present client are adverse to those of the former clients. Now, my Lord, in this case, the applicant has not fulfilled any of those requirements. He hasn't indicated any prior attorney-client relationship between himself and Mr. Mohammed. He's indicated no basis on which he may suffer any harm or prejudice arising from Mr. Mohammed's representation of the second respondent. And in particular, he's indicated no confidential information which Mr. Mohammed might have acquired vis-a-vis himself.
His grounds are totally different.
My Lord, in fact, grounds seem to be that due to Mr. Mohammed's high office, it's inappropriate for Mr. Mohammed to associate himself with the cause of the second respondent. I submit, my Lord, that this is no ground whatsoever for the relief which Mr. Lewis seeks. I point out that he goes so far as to suggest that it's not necessary for the second respondent to retain attorneys at all, a very far-reaching allegation. My Lord, it's of no consequence in these proceedings that Mr. Mohammed is the president of the Cape Law Society, which must consider the applicant's application for pro bono assistance. It's of no consequence that Mr. Mohammed was the vice president of the Cape Law Society at a time when the society dismissed a complaint lodged by the applicant against the Labour Court judge, or that Mr. Mohammed was the Western Cape head of the South African Human Rights Commission at a time when the applicant lodged a complaint with that body. My Lord, in the circumstances, no case has been made out for the relief which the applicant seeks. Mr. Lewis has brought an application for drastic relief without any basis for doing so. He's taken up the time of the court and occasioned costs to the respondents. My Lord, in the course of arguing this application and in the affidavit filed by Mr. Lewis, he's made highly vexatious allegations. He's alleged that Naspers has engaged in a purchase of office, that Mr. Mohammed has abused a statutory duty. He's even condemned the second respondent and its representatives, which presumably includes me, before this court. In all these circumstances, my Lord, I submit that this is a case in which the applicant should be required to pay the costs of the respondents, and I rely in this regard on the basic principle of awarding costs to the successful party as set out in the Texas case 1926 AD. The purpose of an award of costs to a successful litigant is to indemnify him for the expense to which he's been put through having been unjustly compelled to defend litigation. This second respondent accordingly asks that the application be dismissed with costs.
Anything else, Mr. Lewis?
I can only reiterate my objection to Mr. Mohammed, President.
Well, I have you.
Yeah.
Anything else?
With regards to relief,
Well, I think you better stand if you
right.
Is there anything else or what you've already said?
I believe that my application for relief has grounds with regard to the public interest in this case, with regard to the special circumstances surrounding the integrity and status of the TRC final report, with regard to the egregious campaign by the second respondent. I retract my condemnation of the representatives of the second respondent as regard to Ms. Norton's how she has outlined them. It's not a personal attack against her. It's a condemnation of the manner in which the purchase, what it appears to be, yet another purchase of high office by a company that refused to participate in the commission, actively opposed the outcome, and only came up with an apology last year. That's a very, very late, post-dated apology. So I think I'm quite entitled to be making these statements. They're not vexatious in the slightest. I request that the counter case presented by Ms. Norton be rejected, and that my appeal to this preliminary proceeding be upheld.
Yes. This matter has been brought before the Equality Court. The applicant has taken a point in limine, objecting to the second respondent's appointment of the firm Ashraf Mohammed as its attorneys of record. His objection is that it would be inappropriate for them to act on behalf of the second respondent. I have listened to Mr. Lewis's argument and the argument on behalf of the second respondent. In my view, the second respondent has a free choice to appoint a legal advisor of their choice. That is their constitutional right, and I cannot impinge on that right. I can find no reason for curtailing the second respondent's free choice of employing legal representation of their choice. In the result, the objection of the applicant is dismissed with costs.
Thank you. But we proceed, right? It's an eliminate point. So that's empty. I'm just going to procedure. It's an eliminate point, so we're still proceeding.
Yes,
Yes.
the actual matter of
So this is just on that point.
Yeah, he's still going to be in court.
So I will still meet him in court. All right. Thank you.